Hey everybody, Sean Yesner here with Yesner Law. So as I record this video, you can see I'm outside. You can see it's a little overcast out here. We're actually waiting on the storm named ETA, ETA, and the big joke going around social media. What is the ETA for ETA? I really don't think it's going to be a major event. Here we are mid-November, closing in on Thanksgiving. I think the storm's going to be a very low-grade hurricane, if that, probably just a lot of wind and rain. So for those of you outside of Florida, we have enough of a system that we can track hurricanes and know pretty much. I mean, they're always unpredictable. They can always move. And I think the biggest thing here is not to panic when a storm is approaching, not to panic, but to watch the news, to watch the weather reports, to make the decision that you feel is best for your family, whether you want to board up and stick it out or just move stuff that doesn't get blown around or evacuate or whatever it is you want to do. Just, be safe with your family. But that's not really what I wanted to talk about today. What I've been doing is I get a list of the most frequently visited pages of the Yesner Law website, yesnerlaw.com, and I get a report every month of the most visited pages. And so I recently released a short video with the most popular page that people have visited, and today I'm going to do the second most popular page. And so the second most popular page is an issue of whether judgment liens attach to inherited property. And the reason that this video came about and this blog post came about is that we helped a brother and sister combination. Mom had passed and her homestead was inherited jointly by the brother and sister. Well, the sister had no issues, but the brother had a couple of judgment liens against him. And so the question is, do those judgment liens carry forward to the inheritance of Mom's house? And unfortunately, in Florida, the answer is yes, unless the brother had decided to live in the house. Now, in this particular case, the brother did not live in the house. The brother lived out of state. And so what we needed to do was settle the debt with the creditor without the creditor knowing that the brother had inherited the house. Now, I'm not a fan of deceit, but, again, if the creditor doesn't ask what assets the brother has available to pay the debt, I'm not going to volunteer any of that information. So we settled the debt with the creditor. The debt went away, and then brother and sister were able to inherit the house and then sell the house and then split the proceeds equally. In fact, I think that may be how we ultimately used the funds that brother got from the sale of the house, was to pay off the judgment lien, and the brother still walked away with a significant amount of money. So the issue that brings up is, how do judgment liens attach to property? Well, in Florida, there's a couple of requirements. First of all, the judgment cannot be more than 20 years old. There is a 20-year statute of limitations. Now, a lot of people misinterpret this and say, well, the judgment was entered, but the underlying issue that caused the judgment to be entered is beyond the statute of limitations. Well, that doesn't matter. Once the judgment itself is entered, there's a 20-year statute of limitations in Florida. So the judgment has to be younger than 20 years. A certified copy of the judgment needs to be recorded. So what that means is the judgment gets entered, and then the judgment creditor goes to the clerk of the court and orders a certified copy. So the clerk of the court literally stamps the judgment to say this is a certified copy of what's recorded in the public records, and then that document gets recorded. So there's a double recording of the judgment, once when it's entered, and then the clerk certifies it, and then that judgment is entered. A third requirement is that the judgment has to have the plaintiff's attorney's address in it. And this came about because judgments were getting entered and people had no idea how or who to contact to get the judgment released. And so Florida put a requirement in place that the judgment creditor's address, not the attorney's address, the judgment creditor's address has to be in the judgment itself. And so I think those are the major requirements. There's some other requirements based on the timing of the recording. If you have questions about whether a judgment attaches, let me know. Send me a copy of the judgment. I can take a look at it. But basically, it's got to be less than 20 years old. It's got to be a certified copy, has to be recorded. The plaintiff's address has to be in it. Those are the basic requirements. Now, what a lot of people also wonder is, well, what if Mom had judgments against her in my scenario where brother and sister inherited the house? Well, again, Florida homestead law comes in and protects mom's interest in the house. So if mom had a judgment against her, but the house was mom's homestead, then through the probate process, that house can pass to brother and sister without mom's judgments attaching. But that's another reason that for people that want to do some estate planning or probate planning, I would not suggest simply adding brother and sister's name to the title of the house, adding your kid's name to the title of the house, adding your parents' name, adding someone's name, your friends, your siblings, your family. Because if they have judgments entered against them and the house is not homestead, it potentially could be subject to being taken by the judgment creditor for the non-homestead portion of the house. So, for example, if I have a kid, and I do have 2 sons, but if when they reach the age of majority and I add one to the title of my house, because I'm worried that if something happens to me and my wife, that my kids inherit my house. So I just add them to the title. Well, the problem that brings up is, let's say that my son does something wrong. He gets a judgment entered against him, and he moves away to another state. Well, or moves away even to another part of Tampa Bay. Well, when I pass and he inherits the house, or even before I pass, once I add him to title to the house, that title is subject to that judgment lien that he has against him. So if you want to add your kids to the house, if you want to make sure that friends, family, kids, whatever, have the opportunity to inherit the house free and clear of any liens, you need to make sure to do some simple estate planning. We can get rid of that with what's called a life estate deed, where the house is mine for my life, and when I pass, it goes to my heirs. We can do some probate planning, some estate planning. I do have friends that I can refer you to that do probate and estate planning that can walk through this analysis with you. But that's basically what I wanted to talk about today. If you inherit property or are set to inherit property and you're worried about you have judgment liens against you, or the person you inherit it from has judgment liens against them, give me a call. Let me look at it. Let me see if I can help in such a way that the property passes without worrying about those judgment liens. Now let me take a look here. There are other ways, if you do, reading the blog post, if you do inherit property with a judgment lien against it, there are other ways to get rid of that judgment lien. Number 1, you could pay off the debt in full. Number 2, the brother could have moved into the house and therefore made it his homestead, and therefore that judgment lien would not have attached. The sister, if the brother had refused to cooperate, the sister could have filed what's called a partition lawsuit. So the sister would have filed a lawsuit in court that says, "Judge, please split the house, not split the house, but sell the house, split the proceeds." The sister gets her proceeds, her half of the proceeds. The brother automatically, that judgment lien gets paid out of his percentage of the proceeds, and then he gets the rest. So there are lots of options that are available if you're going to inherit a property or have inherited a property and you have judgment liens against you. If the person that you inherited from has judgment liens against them, may not be that big of a deal depending on if it was that person who passed, if it was their homestead or not. So that'll do it for this short video. If you have any questions about inheriting property or judgment liens, please reach out to us. Please give me a call. I can help you with those questions, and I will see you here either tomorrow or the next day with the next video. Whether I'm outside or not, again, depends on Hurricane Eta and what she or he, I guess Eta's a she, decides to do in terms of dumping rain. And as I say that, I can start to feel little droplets falling, so I'm going to take my phone and I'm going to take my iPad. I'm going to head inside where it's dry. I'm going to get ready for work. But if you all have questions, Sean@YesnerLaw.com. Also, if you want to become debt-free, please check out my new book. It's at SeanMYesner.com/become debt-free. Thank you for watching this short video, and I'll talk to you again in another video.